So welcome back, everybody. My name is Carol Sainthilaire. I am the board chair of My Dog is My Home and the executive director of the Waterfront Project, a legal center that provides legal representation, housing assistance, and advocacy to New Jersey residents who are asset limited, income constrained, homeless, or disenfranchised. I'm also your moderator for this session. You have joined the short talk named Reasonable Accommodation and Emotional Support Animals for Housing and Shelter Providers, tracked for our Health and Human Services audience. During the session, you will learn about the obligations of housing providers under the Fair Housing Act with respect to animals that individuals with disabilities may request as reasonable accommodations. So I'm going to give you guys a moment to make sure you're in the right session. So we are very lucky today to have Tim Moran with us. Tim is a deputy chief in the Housing and Civil Enforcement section of the Civil Rights Division of the United States Department of Justice. Very long title. He has over 30 years of experience litigating cases enforcing the Fair Housing Act and other civil rights statutes. Throughout his career, he has tried cases in various federal district courts, argued cases in the United States Courts of Appeals, and drafted briefs filed in the United States Supreme Court. Thank you for joining us today. After Tim speaks, we will be holding a brief Q&A for the short talk. So everyone, feel free to drop your questions in the Wova chat. As they come up, we will get to as many as we can. And with that, I'm going to hand things over to Tim.
Thank you. Okay, so the first thing I want to do is thank you all for two things. First of all, for all that you do to advocate for persons with disabilities. I feel extremely fortunate to be in a job where my job is to help people, but I couldn't do it without people like you who are out there advocating, identifying issues, pushing us for all that. The second reason I want to thank you is thank you for my paycheck, because I work for you. I work for the federal government. So in a sense, like you're my boss. So thank you for that as well. What I want to do is talk just a little bit about reasonable accommodations for assistance animals in housing. Here are the basic topics I'm going to go over, but we'll just get right into it. So the first thing I just want to talk about is kind of definition, which is when we say assistance animals, what do we mean by that? Because it's not actually a word that is in the statute or the regulations. But basically we mean what it says. It's an animal that assists, that does work, perform tasks, assists, or provides therapeutic or emotional support for individuals with disabilities. Although they may share many of the features of pets, but they are not pets. And it's a growing people are realizing that of the benefits of having an assistance animal, of having an animal, a companion animal. So we have seen a growing percentage of fair housing complaints that are received by the Department of Housing and Urban Development and litigated by us involve assistance animals. The complaints doubled, basically about 7 to 8% of the complaints HUD received, and now they are about 15%. And we tried 2 cases just in the last year, assistance animals, where we favorable verdicts in both of them. So it is a growing issue. I also just want to give, I don't know if she's on here, but I want to give a shout out to the person that introduced me to your organization, Janet Hoy. Janet is a professor at the University of Toledo and has written the pioneering and first peer-reviewed study of emotional support animals. And she is someone that I have retained, that the department has retained as an expert witness in a couple cases, including one we're litigating now. So thank you for introducing me to this organization. So most of what I am going to talk about is the Fair Housing Act, which applies to all housing. There are two other statutes that are important, but Section 504 is not one that really we need to talk about much, because it's pretty much it's to federally it applies to federally supported programs, activities. But the big distinction I want
Tim, we're having a little issue hearing you. Sorry.
ADA. Yes.
You're breaking up a little bit.
Can you hear me now?
Yes,
yeah,
it seems like the internet connection keeps breaking up. Yeah. And then also, just as an FYI, you're showing the your presenter screen. So any notes we'd be able to see.
What is that?
It's fine. We have the gist of it. I don't know if display settings would do anything different, but it's fine. We'll see if that might be. There we go.
How about that?
Perfect.
Okay.
Thank you.
Good. Okay.
And thank you everyone for your patience.
Okay. So the Americans with Disabilities Act, the Fair Housing Act applies to dwellings, which is basically anything that is to be occupied as a residence, as your home. So that clearly includes houses, apartments, condominiums. It also may include homeless shelters, even if the stays are short term, but it doesn't include like hotels or motels. It doesn't include truly just transient housing. So with homeless shelters, it really depends on whether it's a place that a person is at least for a return to. And we have brought cases, a few cases involving homeless shelters, including one case where a person with a service animal was denied access to a homeless shelter. And but whether they're going to be covered as dwellings under the Fair Housing Act is going to depend on the circumstances. And there's still, it's still being litigated in the courts. So why does it matter? Well, it matters because whether you're talking under the ADA or the Fair Housing Act matters for what kind of accommodations. So accommodations for service animals, which is a dog that is individually trained to do work or perform tasks for the benefit. And that means that an emotional support animal that simply provides assistance by its training presence, but not but is not trained to do a specific work or task, is not considered a service animal under the ADA. Fair Housing Act, the Fair Housing Act regulations and don't limit accommodations to assistance animals. To service animals. They basically provide what they say is that you have to provide reasonable accommodations for anything that may that is necessary for a person to have an equal opportunity to use and enjoy a dwelling. So that could include what we sometimes call support animals or emotional support animals that that are not individually trained, but nevertheless person presence through emotional support. And I have some information here about how they benefit people with disabilities, but you know all of that. And then the obligation under the Fair Housing Act. So what the Fair Housing Act says is that you have to make exceptions to your rules as necessary for people with disabilities for their reasonable accommodations. And so you can have, it's not illegal to have a no pet or no animal policy. What's illegal is not to make an exception to that when it's necessary for a person with a disability. Now, the HUD has issued a notice in 2020 that provides guidance on assistance animals. And I want to make sure you know about it because it is the official HUD guidance on assistance animals. It replaces an earlier guidance that they issued in 2013. And a lot will know it, and so it's good that you know about it as well. So it basically lays out the steps about requesting a reasonable accommodation and docking an assistance animal. And the most important thing I want to stress is that there's two issues that have come up that have been that have proven to be, somewhat important. The first is that I mentioned the ADA, and a while back, maybe 15 or 20 years ago, housing providers began to say, well, you are prohibiting discrimination. We can't deny a reasonable accommodation to a person with a disability. But under the ADA, that is defined to include service animals. So we should only have to provide accommodations for service animals. And you will still occasionally see housing providers say that, although less so. And there's been a lot of court decisions on it that have basically rejected that and said that because housing is different, has different language, has different regulations, and also the ADA applies to all public accommodations. So restaurants, hotels, many things where you're going to be interacting with people, with a lot of people on a consistent basis, and where it might be reasonable to say that your animal has to be specifically trained. However, when you're talking an animal in their own home, it is different. So that issue it still crops up, but it's basically it is the courts have been ruling pretty consistently, and HUD has certainly taken the position in this guidance that that it is unlawful for a housing provider to say we're only going to provide accommodations for service animals. They have provided a consistence animal. The other issue that has come in is documentation, and where that comes in is this: people can assess whether somebody is blind and has a guide dog, or whether someone has a hearing impairment and is using a dog for their assistance. But housing providers have often said, how do we know that someone really needs, has a disability and needs an accommodation for their animal? What are we going to tell other people? How can we know this? And what HUD has said is that it is permissible for you to request some kind of verification from a healthcare professional that basically documents, that basically says this person is does have a disability and has a need for the animal. And that has to be on that person's. They do not have to, some doctors do, but they are not required to specify the animal, but they should in some way say that they have a physical or mental impairment, that they should provide enough information so that the provider understands that this has a physical or mental impairment that substantially limits a major life activity. But housing providers are not entitled to ask detailed medical records or about the diagnosis or severity of the disability. So it is permissible for someone to request documentation. 2020 guidance was intended to address is that formally a lot of some companies pay a fee, $50 to $100, and then get a certificate recognizing your as get like a letter. And these are still available. You can get a letter from someone who is a medical, who is a licensed therapist of some sort, who will say, who will sometimes write something saying this person needs an animal, even though they have actually never met the person. And what and basically this is useful information, and is not something that a housing provider has to accept. Now, it's understandable why people would they may not have reliable healthcare insurance, they may not have a reliable provider, they may not have a current provider, and so if they get to come up. So it's not, it isn't necessarily, it's not dishonest on their part, but it is better that you steer people towards it is best that you steer people towards documentation from someone who is actually has personal knowledge of. And then the last issue I want to just address is about exotic animals. The guidance says basically that if it is an animal that is commonly kept in the household as a pet, such as a dog or a cat, then it is presumptively, then all they have to say is they just have to provide some documentation if requested that yes, they need this dog. How exactly why this particular dog is necessary, just that the dog helps or the cat helps. If, however, it is not an animal that is commonly kept as a pet, then the person with the disability has to provide some explanation as to why this more exotic animal is something and is needed rather than. So I apologize if people were not able to hear me. That's basically all I have. Thank you, and I'd be happy to take your questions.
No, yeah, we'll just for everyone in the chat, we are going to make the slides available to everyone, and we'll work with Tim to maybe re-record his talking the slides and then put that in the Wova app for you to be able to view after the fact. So I know that there are some questions. I have a whole bunch in terms of how these things are enforced by HUD. I recently had a person reach out about, I run a legal clinic, reach out saying that, you know, they have a letter from their psychiatrist saying that they could have an emotional support dog, and the letter was documented, and she actually owns her condo, and the HOA said that because she is not blind, she cannot have a service dog or an emotional support animal, and that is the law. My friend is obviously not an attorney. So what advice or what would you give her, or what actual pushback does she have under the guise of the federal government?
Well, just can this is an emotional support animal?
Excuse me, it was for an emotional support animal, and it was for a dog, and the letter was written by her psychiatrist.
Right. Well, I mean, she should look up the guidance on this website, and she should maybe send them a web page just on assistance animals, which will have a link to the guidance, and she basically can say, it's not limited, you know, I urge me to have an emotional support animal, and so you have to accommodate that, and hopefully that would do it.
If not, that's the last thing I caught.
File a what?
So you said she can send them the guidance and see what they say, and if they still push back, what's the next thing she should do?
File a HUD complaint.
File a HUD complaint, right? And This is just for an emotional support. It doesn't matter that it's not a legitimate service animal. And I'm using the air quotes just because people sometimes are like, well, outside of this amazing place that we're at with my dog is my home.
if it is the Fair Housing Act, if it is housing, then any animal that provides assistance can qualify. It is a service animal. And so
yeah, folks, I think that's one of the like biggest things. I know we're having the tech issues is that under the Fair Housing Act,
file a complaint.
Tim, so we have another one, and I feel like the answer is going to be the same, is to file a complaint. What are some steps, options available for folks whose landlords refuse to allow ESA? There's a tremendous shortage of affordable housing here in Maui. And at the Humane Society, we get about a third of our surrenders due to not being able to find / afford pet-friendly housing. In some cases, the family have had ESA letters from providers and still had their landlord refuse and surrender due to fear of losing their housing. So it looks like just submitting a complaint, and that can be done via the HUD website.
Yes.
Great. Thank you. So what if a person has more than one service animal or emotional support animal, but has the documentation for more than one? This is something that actually Christine and I at the NAH conference in Oakland last month, someone's like, oh, well, it's a hoarding issue. So what do you say about that?
Well, I mean, there's nothing in the law that limits the number.
So there's nothing in the law that prohibits,
but,
okay.
There's that prohibits it, but I would just say there is common sense that most landlords can understand that somebody or medical provider, emotional well-being. Most people can understand that, and they may get more suspicious. So if they need it, they need it. But I guess it is. There is often people that have a concern about fraud or overreach, or those kinds of questions, and then you just have to be prepared, I think, to articulate that you really do need and see what happens.
Yeah. Awesome. Tim, thank you so much. And thanks everybody for joining.